Good morning. This is the Colorado Energy and Carbon Management Commission. This is day two of docket 240900229, produced water rulemaking. We will start by calling the roll.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ray, Commissioner Robbins,
Here.
Commissioner White.
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Good morning, everybody. Again, produced water rulemaking, 8:30 on a Friday morning, February 28th. We had indicated yesterday that we were going to proceed into executive session this morning to receive legal advice. AG Stafford, do you want to provide any information to us, or can I just make a motion?
Sure, Chair. I have a brief script I'd like to read, if that's okay.
Go for it.
All right, thank you. And for the record, my name is AAG Caitlin Stafford. I am representing the Commission in the produced water rulemaking. Pursuant to the open meetings law, the Commission is entitled to enter into executive session at this meeting to receive legal advice on legal issues presented in the produced water rulemaking. Chair, I invite you to encourage a motion to enter into executive session for the matters I just named.
So moved. We have a second?
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. All right, for you intrepid members of the public, there's 24 of you. We're going to leave this session. We're going to go into a Zoom session for executive session. No decisions will be made. We will receive legal advice. We will return here. It's always difficult to guesstimate the time frame, probably about 30 minutes. We will not return before 9 a.m. Let me say it that way, because I suggested to everybody yesterday that they could Zoom in at 9 a.m. for the meeting. So with that, we will see everybody soon back in this executive session. All right, welcome back. This is the Energy and Carbon Management Commission. It is the 28th of February at 9:05. We are returning from an executive session, and in that regard, I would recognize Assistant Attorney General Stafford.
Thank you, Chair Robbins. As the Chair just mentioned, we're returning from executive session. During executive session, the Commission received legal advice on issues presented in this produced water rulemaking. No decisions were made and no votes were taken. The Commission did not deliberate during executive session. Chair Robbins, I invite you to encourage a motion to exit executive session.
So encouraged.
So moved.
Second.
All those in favor of the motion to exit executive session signify by saying aye. Aye. Any opposed? Motion carries. All right. We are again in docket 240900229. Yesterday we heard from our staff. We also heard from all of our stakeholders. We heard cases in chief and short bits of rebuttal testimony. We have undertaken the executive session to receive legal advice. I think we are now set up for deliberations this morning. And I would like to, if I don't normally do this, but I would like to call upon Commissioner John Messner to weigh in, given the work that he's done on the Produced Water Consortium and his leadership in that regard. I think it makes sense for us to hear some deliberative thoughts from you, if you're okay with that.
Sure. Happy to kick it off here. I think it's clear by this proceeding that we've been involved with here and the work that's been done on this topic over the last 3 years, that people realize that water is an important resource in the state of Colorado. I appreciate all the work and effort that's been done by the consortium, ECMC staff, and stakeholders to work on ways to both decrease the amount of fresh water used and increase the amount of produced water used in oil and gas activities across the state. This is an incredibly challenging and complex topic. As in my experience, topics associated with water tend to be. But to overcome big challenges, it takes big thinking and big ideas and big collaboration. And I've seen that occur throughout the 3+ years that I've been engaging on this topic. As the data and studies by the consortium provides, there are opportunities to increase the amount of reuse and recycling of produced water across the state. It also shows that each basin in the state is different with different produced water profiles. It also shows that in order to further conversations in the space, we need more data to allow further analysis in these different areas across the state. I think the targets and timelines developed in the recommendations from the consortium have been described by parties as both modest and ambitious. I think they've indicated that it's possible to reach and challenging to reach. I think that makes me think that we're probably in the right place in these rules for both the targets and the timelines. I think the data and studies provided by the consortium also show that we have to be careful about unintended consequences associated with our attempts to decrease the amount of fresh water and increase the amount of reused and recycled produced water in oil and gas operations across the state. Increasing the amount of required reuse and recycling of produced water too quickly and without the necessary infrastructure and technology in place could in fact create more harm than benefit, even if it ultimately decreases the amount of fresh water utilized in oil and gas operations. At the same time, not being ambitious and forward-thinking in our targets and goals towards reuse and recycling of produced water does not get the state where it needs to be in the conservation of an important resource of fresh water. I think the credit system developed and the portfolio-based compliance help address both of these items. I don't see any need to expand the credit system that's been proposed to anything besides in-basin use. I think the draft rules before us that include the concepts and ideas developed by the consortium, by staff, and by the consensus group have struck a good balance between increasing the amount of reuse and recycling of produced water and reducing the amount of fresh water used in oil and gas activities in the state, while ensuring the protection of public health, safety, welfare of the environment, and wildlife resources. Finding common ground between diverse stakeholders is hard, but that has occurred here, and I believe the resulting product is both workable and protective. It also acknowledges that more work is to be done and needs to be done, and that is important as well. Statute requires us to ensure that the reuse and recycling requirements we promulgate will not increase air emissions. Like water, air emissions are a very complex and challenging topic. I support the development of a working group of stakeholders that include CDPHE and ECMC staff, industry, produced water and air emission experts, the director of the Produced Water Consortium, and conservation and environmental justice NGOs to work on developing track and how to track and calculate the air emissions associated with the reuse and recycling efforts to culminate into rulemaking in 2026. I also acknowledge the significant barrier created by HB 23-1242 to reuse and recycling efforts on the western and southern slopes by a blanket prohibition of centralized produced water treatment facilities in disproportionately impacted communities. I agree that it is illogical to penalize the operators who have been leaders in reuse and recycling for decades in the state. And why it may be arguably legally possible to attempt to solve this issue within this rulemaking, I believe the best and most pragmatic solution can best be found by taking a bit of time to work through the issue within the Colorado Produced Water Consortium and other stakeholders for a recommendation that would be provided to ECMC, culminating in a rulemaking in 2026 for options to remove this barrier. There are many other barriers to reuse and recycling of produced water that have been identified in the reports developed by the consortium. And I think it's important to ask the consortium to continue to work through these barriers and develop pragmatic recommendations for solutions as their work continues. These include storage and transportation, legal and liability issues, fit for use classifications, data improvement, testing standards, community and environmental justice concerns, research gaps, and water share agreements, amongst others. I would also ask the consortium to continue to collect, refine, and analyze basin-specific data to inform conversations around basin-specific considerations and targets that would result in recommendations to ECMC for future rulemakings or policy decisions on the topic. Other concerns brought up by stakeholders around compliance, reporting, and definition clarifications, I believe can be worked through in the statement of basis and purpose and implementation guidance to address the concerns expressed. I don't think any further expansion of the definition of produced water equivalent or alternative is necessary. I believe the definition as presented hits the target. So those are my initial deliberative thoughts on there. I do want to give one final thought, and that's a thought of appreciation to all that have been involved in this rulemaking and the processes that have led up to it. I think all of you in the state of Colorado are once again showing what it means to lead, finding ways to come to pragmatic solutions to challenging topics. At times this means compromise, at times this means consensus, and at times this means frustration. But I'm always amazed that we continue to find ways to work together, to move forward, and to lead in accomplishing big goals. And I think the work that's been done on these rules and the efforts behind them are another great example of this. So thank you, Mr. Chair. Those are my initial deliberative thoughts.
Thank you very much, Mr. Messner. As always, you've come through brilliantly in terms of summarizing, I think, what I at least agree with in large regard. Do others desire to weigh in? And that includes you, Commissioner Ray, and you, Commissioner White. Commissioner Ray?
Thank you, Chair Robbins, and thank you, commissioners. And apologize I wasn't able to join you yesterday afternoon, but I enjoyed hearing the presentations yesterday morning. I just want to echo comments that Commissioner Messner made yesterday, recognizing the contributions of the Produced Water Consortium members in the work they did to inform this rulemaking. It's an impressive group, represents diverse interests, and they've really done an incredible amount of work over the last year. And that is thanks in part to the leadership of Commissioner Messner, but also the consortium staff, including Director Hope Dalton and Assistant Director Aaron Sidlako, and the ECMC staff that support that consortium. So a lot of work went into that, and appreciate the staff that bear the brunt of that work. I also want to highlight the number of parties in this rulemaking that came together to develop an approach that this commission can consider. I think that collaboration represents a model that I hope can be applied in future rulemakings, as in my opinion, the state is served best when diverse stakeholders can seek common ground on complex and challenging public problems. And I think this was a good example of that. And finally, I'm excited to see this commission consider innovative policy solutions like the credit trading program to help achieve the statutory charge of House Bill 23-1242 to reduce freshwater use in oil and gas operations. I think that, as Commissioner Messner just articulated, represents leadership that Colorado can take in the nation. So that's a really exciting thing. So appreciate all the work that went into this, and that concludes my comments.
Thank you, Commissioner Ray. Others with comments? Commissioner Ackerman.
Thank you, Mr. Chair. And I actually don't have a lot to add to what Commissioner Messner said. We have a consensus draft here, and we specifically asked parties to work together. And many did, and it resulted in what I also see to largely be a workable implementation of these rules. And I do want to thank all who participated in that effort, but also to all who participated in the rulemaking in general, and echo the thanks to the consortium. I specifically wanted to recognize and thank Commissioner Messner for his leadership on the issue. It's been instrumental for me in this effort. I'm very grateful we're addressing this issue. I agree with many of the parties and wanted to highlight some of the comments by Greenhouse Connection Center and Citizens for a Healthy Community. Water is such an important part of what we're doing here in Colorado in general. And I particularly, while those two groups weren't members of the consensus draft, I particularly appreciate their involvement and their and their pushing on the status quo, and their good preparation in preparation for this hearing. I think we have a lot of work left to do to ensure that we're doing the best we can with regard to water and oil and gas development. I too appreciate the inception of a trading system. I do think it's an important part of the program, and not just an innovative solution. I think it's imperative to the working of this program. I also agree that trans-basin transfer of credits should not be included in the system. I think that would be counterproductive. And I also don't think we need increased targets on the West Slope, and particularly in the Piceance. I appreciate the good work that's been done there for many, many years, and am grateful for the operator's proactive approach there. I also agree with Commissioner Messner that I think it's important that at all times, not just on this issue, but in all issues, we understand and consider all impacts of the requirements that we impose and the actions that we require. I also support the convening of a working group to work on air emissions impacts associated with produced water reuse and recycling. Mr. Wynn's words certainly rang true to me. I was a young wildlife manager south of Rifle for a number of years, and when I was there, I remember the near endless procession of water trucks that was up and down it was essentially water trucks and me up and down the back roads of the area south of Rifle. And I agree with Garfield County and the western and rural local governments that sending brigades of water trucks through the rural areas of that part of the state is a very difficult retrograde here. I think that has been the result of broad census block based mapping for DI issues, and that certainly causes me concern. I do think that issue needs significant more work, and certainly support an approach that would do so. That said, Mr. Chair, I'm grateful for the parties that have participated. I do believe that we have a good consensus draft before us, and I'm generally supportive.
Thank you, Commissioner Ackerman. Commissioner Oath?
Thank you. And I don't have much to say because I agree with all of the comments that have been shared so far. So thank you to my fellow commissioners for saying that so articulately. One thing that has been on my mind is how important the trading program is to be intra-basin and not inter-basin. And I think that has been stated several times here in deliberations, so it's clear here on the record. I do want to make sure that that's clear also in our statement of basis and purpose. And then somewhat along those lines, there was a comment during the testimony about, forward looking, about thinking about both the targets and maybe also the trading system being thought of in terms of river basins instead of geologic basins. And so Commissioner Messner, not to put you on the spot, but I don't know if you have any knowledge or if that has been discussed in the consortium, or if you have any thoughts to share on that. I thought that was an interesting comment that I wanted to hear a little bit more about from you.
Thanks, Commissioner Oath. Happy to share a little bit of information about it. I mean, certainly, I think to be consistent on how water is looked, it makes sense to do some analysis and evaluation on a watershed specific in a watershed specific way. I think we continue to look at how the data that's being provided by different reporting requirements may be organized to be able to look at things in different ways. And I think that that's something that we can also ask the consortium to look at to see if there are ways to organize that data to allow for an analysis and considerations to be done on watershed specific in a watershed specific way. And so I think it's a good idea.
Thanks for that. And that's all that I would share, just reiterating the appreciation for all of the hard work that has gone into the work of the consortium, and as well as all the parties to this rulemaking hearing to bring us to this proposal, and generally really in support.
Commissioner Cross?
Thank you, Mr. Chair. I want to start off by saying thank you to everyone involved in the work that led up to the creation of the consortium. I want to thank all the members of the consortium, including Commissioner Messner, for their hard work on that. And I want to thank the parties to this rulemaking as well. As has been discussed, I think the amount of collaboration that has occurred in getting us to this draft that we're looking at before us, I think is important, and I hope to see it in further rulemakings as well. I think it's been very helpful to really narrow down the issues that we're seeing, and as opposed to focusing on kind of big picture, we can kind of get down to the real nuts and bolts of how we can clean things up. So I'm going to go over a couple things before going into a little bit more detail about one of the issues. I agree with creating a working group to discuss the emissions issue. I do think this is distinct from the work that the Produced Water Consortium does with the specific issues related to air emissions studies. And so I think it's important to have a working group that includes experts like we have at CDPHE, but I do think it's important to have input from members of critical groups that have opinions that will be necessary for what we're trying to do. That includes environmental groups, environmental justice groups, operators alike. I think that one of the things that's important is, as we put together the SBP, based on a couple of the things that we heard yesterday during testimony, I think we need to make sure that we clarify in the SBP that centralized E&P waste management facilities is not defined so broad as to include all systems, as was talked about, to make sure that the entire system is not included in there. And I think that, I don't know if we need to look at specific language from that, but I do think that the testimony on that is important to make sure that it's not too broad. I also think it's important to clarify that Class 2 injection wells are not included. One of the things that I think needs to be researched and clarified, especially moving forward in the Produced Water Consortium as well, is the idea of the reporting on the transportation. This was discussed yesterday, and I do think it's an important point. You know, I think in a lot of situations, you're going to have operators hauling their own water, but there are going to be instances where there's third-party transportation groups that are going to be moving it and might be coming from multiple operators. And so I think trying to make sure that we narrow down on how that reporting needs to be done is something that needs to be fleshed out if we're going to be working on that. And so I think that's a critical thing that can be looked at by the Produced Water Consortium as well for recommendations. I will say I'm also in agreement with the draft provided. It's been called the consensus draft. Others suggested it should be called the collaboration draft, but I do think the draft before us is appropriate. A couple things that I want to touch on for it. One is the removal of the OGDP by OGDP requirements, and I do think this was critical. One of my initial concerns was having it done location by location creates a perverse incentive, because there would be locations where the numbers would not be met. They could probably come close, maybe hit 3% instead of 4%, but given infrastructure, geological concerns, et cetera, they may not be able to hit the required reductions. And I think that if you just left it at 4%, you would also have the perverse incentive of operators just trying to do the bare minimum. Whereas now, by having it broader, you're allowed to create additional reductions that will allow you to bring up those other areas. And so I think the incentive to try and make sure that additional reductions are done where they can be done is going to be beneficial overall. I think with the credit trading system, I think this is an appropriate way to create those proper incentives. And I will be curious to see how it works. I know there's been a lot of discussion of, we're going to evaluate this as we move forward with produced water discussions in the future to see if the credit trading system was effective or not. And I do look forward to seeing how it will work. I know there's been a lot of concerns about it, but I do think it is an appropriate tool to create those proper incentives. And I also agree that it should be intra-basin trading and not inter-basin trading. I do want to make sure that I highlight that. So the one thing I do want to spend a little bit of time on is the issue of the prohibition in disproportionately impacted communities. And I think this is appropriate, and I apologize in advance for going into a little bit of detail on it, but I do think it is important. So I want to start with CRS section 24-4-109. And this was talked about quite a bit, and a lot of parties said we do have the ability to try and make sure that we can tailor what's being done here within our rules. And I think the important part of this is when you look at section 2A1 and subsection B, it says that in applying the definition, we may, quote, prioritize or target certain criteria of the definition. And I think that it's important that we have to look at that. And when you look at what the definition of disproportionately impacted community says, it specifically talks about in the statute one or more of these factors. And so I think it cannot be looked at to say one or more of these factors, but you can prioritize one to make that a disproportionately impacted community. I think the critical thing is you will automatically have the disproportionately impacted community as long as one of those factors are met. So to give meaning to the statutory language of prioritize or target, I think it has to mean one of two things. You either provide additional protections or you provide some kind of reduced protections consistent with what the ultimate intention of the rulemaking is. Now, I think what we've seen from the parties here, such as Westslope, Koga, and others, is kind of the argument that we're going to provide maybe some less protections. They specifically talked about not trying to redefine what a disproportionately impacted community is. And I do think that that's important because I think ultimately what we have to do is look at the statutory language for our mandate, and that's 3460-134. And when you look at what 3460-134 subsection 5 says, we are supposed to create rules. And it says specifically in subsection B, the commission shall not adopt a rule designated in the data. And then, sorry, I want to look at C, not B. Subsection C says, on or before December 31st, 2024, the commission shall adopt rules to require a statewide reduction in fresh water usage. And then in subsection D, it specifically says, the rules adopted pursuant to this subsection 5 must include, and subsection 2 from that says, a prohibition against placement of a new centralized produced water storage or treatment facility in a disproportionately impacted community. Now, while I agree with the legal arguments provided that we do get some discretion under the EJ Task Force Act there to try and prioritize or target some of what we're trying to do, ultimately, we are guided as an agency by what the legislature mandates us to do. And so I think the issue we have here is in 3460-134-5, we are told there must be a prohibition. We must enact a rule that says there's a prohibition. So I think that is going to supersede any kind of argument that we can prioritize or target what protections are going to be placed on a DI community. And therefore, we don't really have the wiggle room that's talked about in some of the testimony yesterday. Now, I want to make sure that I encourage the legislature to look at this issue. I think as we heard from a lot of testimony yesterday, a full-out prohibition of new centralized E&P waste facilities is again going to have many of these perverse impacts and incentives that were talked about. I think there were some great examples of a lot of these centralized E&P waste facilities are currently miles and miles from the nearest RBU. And sometimes even the closest RBU, which is miles away, is a temporary RBU. And a lot of times those people are already in support of the centralized E&P waste facility being there. And so what we've when we look back to our cumulative impact rulemaking, one of the things that was talked about a lot was CDPHE and others telling us that the idea behind the disproportionately impacted community is the keyword community. It's supposed to be proximate to people. And so I think having a blanket prohibition in DI communities, which in a lot of areas in the DJ Basin makes sense, but in a lot of areas on the West Slope especially, where you have these wide swaths of land without any people, you're not protecting any communities by having it being done on the census block. And so I would encourage the legislature to consider going back and amending this legislation to say, rather than a prohibition on DI communities, period, adding some sort of proximate approach to people. And I don't want to opine at this point in time of what the appropriate proximity should be. I think that that's something that's been talked about in other situations, and I do think it's important to get the legislature's view on that. But I think, as we heard yesterday, we don't want to have this view. We not only heard that from operators, I think we even heard Dr. Vasquez yesterday talk about needing a solution that's going to still protect without being unduly burdensome. And so I think this is something that all the parties can agree upon, that you're kind of handcuffing the capabilities of future reductions if you're preventing some of these facilities from being placed in disproportionately impacted communities where they're not actually going to necessarily have an impact on communities. So I appreciate the time and kind of fleshing out my thoughts on that legal interpretation a little bit, but I did think it was important to make sure that I addressed it, at least my thoughts on how it works, and again, encourage the legislature to consider modifying that legislation so that we don't have that negative impact as we continue to try and have reductions in the produced water and increases in the recycled water.
Thank you very much, Commissioner Cross. I appreciate those deliberative thoughts. I think it's good advice. Commissioner White.
Thank you. Excuse me. Thank you, Commissioner Robbins. I just want to echo the opinions and the appreciation of all the fellow commissioners. There's clearly been a tremendous amount of work by everyone involved in this rulemaking effort, adding a lot of robustness to the process. I would like to note how this rulemaking relates to CDPHE in particular, specifically that all commercial produced water infrastructure related to treatment, discharge, and disposal are regulated by programs within CDPHE. To that end, I would like to echo Commissioner Cross's thoughts that for these rules, a disposal operation should probably not include a commercial impoundment or class 2 well. I leave it to the other commissioners to decide whether an open air evaporative pit should be included. Finally, I just want to note that the cooperation between ECMC and CDPHE has only grown over time. We appreciate that, and we look forward to the partnership continuing.
Thank you, Commissioner White. Well, we've heard from everybody. I'm in very much agreement with all the things that I've heard from my fellow commissioners. Don't need to reiterate any of that. Thanks again to all parties that were involved. I believe we've got a few things that we need to sort of tie up today. I believe it would be appropriate for us to have a motion to approve the consensus draft dated February 24th. Second, I think that we need to direct staff to revise the SBP in accordance with the deliberative thoughts that we've heard from commissioners today. Third, as we heard from Director Murphy at the beginning, they would like 2 weeks, and so we would continue this meeting until March 12th, at which time we would reconvene and take up the revised SBP and make sure that we're all comfortable that it's consistent with our deliberative thoughts. Fourth, that between now and March 12th, just sort of inform our parties that we're not interested in further changes to the rules that we've kind of preliminarily approved the rules with the motion today. And we're really waiting on staff to address the SBP, and that's what we would be taking up. I don't believe it's appropriate to close the record so people can still talk to us, but it really is, at least in my mind, more around the lines of the SBP and the direction that would be given there. And then I think fifth or finally, or I don't know how many points I've got to this point, but ask or provide directive that we do want a stakeholder group. And it might be two stakeholder groups, and this is something I'm interested in hearing from fellow commissioners. One issue is the air emissions that need to be addressed, and then the other issue is the DIC and the prohibition issues that need to be addressed. I'm in agreement with Commissioner Cross that I think ultimately that is direction back to us and then from us to the legislature to try to achieve a fix that is consistent with protections of DIC, yet does not include a blanket prohibition within DIC. Those are two sort of disparate topics, and so I'm wondering if it might be we have two little subgroups that are looking into that. And I'm going to throw this out here, but Commissioner Messner, I would wonder if you could run lead on the subgroup that addresses the DIC prohibition, and Commissioner Oath wondering if you could run the subgroup that addresses air emissions. And I'm just throwing it out there just to get some thoughts out there. I think those are the sort of procedural things that we need to accomplish. AG Stafford, if you could raise your hand or visualize, did you see anything else that we need to address that I might have missed in my notes?
I think you got it all, Chair. I think it might be worthwhile just to clarify that that the preliminary vote to approve the consensus draft rules is not final agency action until the SBP is done and everything is voted on. So just to make that clarification.
Okay. So clarified. That's a 6 point. Commissioner Messner, are you willing to undertake that assignment on the DIC prohibition stakeholder work group?
Yeah, I am. My suggestion there would be, I think the consortium is well suited to manage that with the addition of other stakeholders that are interested. And I think the consortium already engages in some subgroups for certain topics and, has identified as a work plan in the future is looking at addressing barriers associated with reuse and recycling. And this is the one that has always been at the top of the list. And so I think consortium members have already been thinking about this topic, and I think other stakeholders could be involved in a subgroup that's part of the consortium discussions. And so if you're amenable to that, that's where I think it would be best housed.
I think that's fine. I think bringing in other relevant parties as you deem necessary also makes a lot of sense. And then to both you and Commissioner Oath, is divvying up of these two things into two subgroups, does that make sense to folks? And we're kind of sort of making this up as we go. Commissioner Oath, did you want to weigh in on that?
Sure. I think, yes, that's my understanding is that what makes sense to me, and it seemed like many of the parties indicated this as well, that the people needed to talk about the air emissions issue may be a little bit different than the group of people involved in the consortium. So yes, I think that makes sense.
And are you willing to head that for us?
Yep, sure, of course.
Okay. Well, with that, AG Stafford, visualize yourself again. How do I put all that into a motion? Can I say so moved, or do I need to recite all of that again?
So there were 6 parts there. I think it probably would be best to say, offer a motion to preliminarily approve the consensus rules from Monday, February 24th as drafted. Noting that this is not final agency action.
Right. And then, and also directing staff to revise the SBP in
Yes.
accordance with the deliberations this morning, to continue the rulemaking to March 12th, at which time we would reconvene to review the revised SBP to ensure consistency with the 224 draft and our deliberative thoughts. And included in the motion is direction to Commissioner Messner to utilize the Produced Water Consortium and other informed entities to address the DIC prohibition, as well as direction to Commissioner Oath to convene a sub-working group to address the air emissions component of this. The record is not closed. However, we are not contemplating additional changes to the 224 draft and would reconvene again for final deliberations on March 12th. How's that?
That sounds about right.
All right, and we have a second. Do we have further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Work well done, folks. Thank you, everyone, for participating with us. We will reconvene on March 12th, and that concludes the business of the agenda for today. I would move adjournment.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
See you, folks. Good work.